everyone. Hope you're having a great day. I am Kevin Kelly. He is, of course, Paul Gerard. We are Gerard and Associates. Check us out on our website at gerardassociates.com. This is the G&A Way podcast. Thank you for tuning in. Hey, and check out this podcast. We're now on Apple, Spotify, Podbean, Google, all the biggies. So we're going big. Check us out. So kick this off. Long overdue topic, Paul, the relationship between you and I.
Yeah. Okay.
Yeah. So, and more specifically, the relationship between Gerard and Associates and the law office of Kevin J. Kelly and how they interact and how we work together to help out EMTs and paramedics who may be in some distress.
Right. Yeah. So probably a good way to start is a little about our backgrounds that maybe people don't already know. They probably know about me because if they've listened to previous podcasts, but I've been involved in EMS for, 44 years. Since 1979, actually, is when I get involved to present, and been doing EMS quality improvement as Gerard Associates for 18 years. But what they don't probably know is your background and who you are. So you're an EMS veteran as well. You started in the 80s, early 80s, mid 80s, something like that. So you've been around as long. But then you graduated, put on your big boy pants and went off and became a lawyer. And so you've done legal work for a number of years, both in EMS as well as other types of law. And you also have a significant experience in compliance, working for some major healthcare institutions in Connecticut and Massachusetts as a compliance officer. So you've had three careers rolled into one, and all three of those are very, very relevant to the EMS quality improvement realm. So we talked, you and I, offline. We were preparing for this, and we've often discussed the connection between the legal component and the quality component. And if the quality component is bad, how that can get you in trouble into the legal component. We often lecture our providers when we're talking to them about, using the kind of, well, if you're on the witness stand, how would this hold water? How well would this go? And that sort of thing. So we've done a bunch in this realm. Why don't you jump in and talk a little bit about the legal connection and some of your work in that regard?
Yeah. I mean, we go back, and we go way back as EMS theorists, EMS philosophers, and we both climb the corporate ladder respectively in all phases of EMS: the clinical, the management, the leadership, the CQI consulting, and after I want to say 20 years. In clinical leadership and management, I went into somewhat of a semi-EMS retirement. Finished law school, passed the bar, and started this practice. And because of our relationship, because of the healthcare background and such, we were able to have this symbiotic relationship between the EMS CQI and the legal aspect of this. And, frankly, not only am I a lawyer in private practice, and I by and large do focus on criminal matters related to guns, drugs, alcohol. I do quite a bit of self-defense work. But of course, I also act as general counsel for Gerard and Associates. And in that realm, sort of help you navigate all of these traps for the unwary with respect to the consulting practice and healthcare in general. I guess what we want to talk about is really the symbiotic relationship between me as the lawyer, separate and distinct from G&A. And how we get work from time to time. We don't do a lot of it. I don't advertise that I am an EMS lawyer. I don't hold myself out as an EMS lawyer per se. I'm a trial lawyer who happens to have a pretty significant background in EMS. And therein lies where I can and G&A can be of value when we get those anxiety-ridden calls from EMTs and paramedics who just got a letter from OEMS, a notice of agency action that they're going to suspend or temporarily revoke their license, and their hair's on fire. And this is where you and I work together in our distinct and separate roles.
Right.
You as really the nation's foremost EMS CQI consulting firm. I mean, you're all over the country now, and me as trial lawyer, we combine our 20 plus years in EMS, and we hope to provide some value added service to those who are in distress.
Right. So how does this go
So,
down? How does this go
yeah,
down?
so,
When someone,
so, yeah, go ahead.
when you get a call, because that's how normally it starts. It either starts with you getting a call from a client or me getting a call from one of our clients saying, OEMS sent us a letter and there's a problem with a call type of thing. So, I think most agencies, because, we're in the EMS field and we talk directly to EMS agencies, they kind of know their end when they get that call from OEMS, but they may not know your end. So how do you see this?
Yeah. So I get I'll get a call from an EMT or paramedic that got a notice of agency action, and I go through my dog and pony show as a lawyer. In the first thing, we do free consultation. We take in the information. We get a copy of, and it's the most important part of this, getting a copy of that redacted ambulance trip sheet. I get a copy of that, and I want it completely redacted. Provider information, ambulance service information, patient's name, just the narrative and the beefy part of the facts, and I send it to my expert. And my expert happens to be Gerard and Associates. 18 years of reviewing run reports, over 300,000 run reports reviewed. I mean, GNA has got the beat on this. So I send the redacted run report to you, and you send it through your process without, tipping the pitch, so to speak, on what kind of work we might be doing. And your auditors, your EMS CQI coaches take it from there, and they review that run report and pick it apart. Try to identify all the strengths, the weaknesses, the opportunities, and then we come back and we talk about it. And overwhelmingly, after we review this and your experts review this, what do we say?
How did this get through the Swiss cheese? How did this get by agency and the CQI process?
How did this get through the CQI process? And frankly, what a shame it did, because there are so many things that start to snowball that if you got legal and you got CQI expertise at the starting gate, we can start pulling that apart. Sometimes the government agency doesn't get it wrong. Get it right. Sometimes the state medical director is missing something because he's making his decisions on protocol violations based on the investigation. So that's kind of how it starts. I give it to you, and we go from there.
This is a subjective process, right? I mean, the OEMS has got a job to do. They're trying to prevent bad actors. If they get a complaint, they've got to follow up on it. But and so that's just the job. They got to do it, right? So that's, in fact, we need that function to operate so that you don't have rogue characters out there.
Yeah.
But you're right. They do sometimes get it a little wrong. And it's a subjective process, reviewing the protocol. What does that really mean in terms of should they or could they, or, is it mandatory versus optional for the provider to have done what's in protocol? And to what degree did the patient actually meet the criteria in order to trigger the element of the protocol that's being challenged, per se. So,
right.
We see a whole lot of that. And often when we talk, we usually talk through the agencies, with the agency chief or medical director, and then they discuss it directly with OEMS or any body that's coming to investigate after we've had those discussions. But generally you hear that, when they discuss these points where the medical director often will even disagree with OEMS's interpretation of the protocol, or whether it's relevant and applies. Right. So that makes it very challenging. So you don't want to go it alone, right? If you have a highly
No.
subjective process, you really don't want to wing it and say, well, I got this covered. I'm going to argue this for myself and just face off with anybody, whether it's
Yeah.
OEMS
Yeah.
or legal counsel from, the folks who are complaining, the family members who are calling you to complain. You really want to get that independent, unbiased view of not only the clinical call, but then the legal unbiased view of what have you got here that might expose you to risk.
Yeah. And once you and I go through and we hash this thing out, and this is before we get, and we review the run report before we even look at collectively that notice of agency action. And then you and I discussed the likelihood of, whether we should take on the client, would we prevail? What are the arguments? What's the likelihood of success in reducing some of these allegations?
Mm-hmm.
And then, obviously the expense of hiring Kevin Kelly and the expertise that Gerard and Associates provides to put on a defense. But here's the thing, and you mentioned it, and we seem to say this all the time too. We are brought into the process way too late.
Right.
And we oftentimes, well, I think the majority, all of the time, we get these after OEMS has already interviewed the EMT and paramedic.
Right.
So we didn't have an opportunity, to sit down and discuss this case prior to that. And that's a shame. Because again, we look at these run reports and we say, how did they make it through the QI process, the CQI process? And because it didn't make it through the CQI process, nobody sat down with the provider.
That's the problem. Nobody knew it was coming. Is usually
nobody knew it was coming.
Yeah. So we get a number of our clients we get because they are going through that very process. That's how we actually get hired. Is through that process they discover that there are holes in their CQI Swiss cheese.
Right.
And that these things have happened. A deeper dive, either by OEMS or by the agency saying, well, what happened on this call is what we do for a process on every call. So if that one got through, there's probably others getting through. And that's when they'll call us and say, hey, can you take a look at this, report? OEMS is on our doorstep type of thing. And that's often how you get it too. It's after the fact.
Yeah.
So, agencies have to be more proactive. They've got to have a robust CQI program that can catch these things, because if you catch them early through the CQI process, you have the ability to say, let's take a legal review of this call just to see if we've got any risk or exposure, even if you haven't heard anything from OEMS. But more importantly, it allows you to craft a proper response and a proper action plan for that call should OEMS or some other entity get involved and say that they think you've got major problems here. So here in Massachusetts and in other jurisdictions as well, but it's notable here in Mass, is that if you're required to self-report, but if you self-report along with an action plan, we found this ourselves, here's what we are doing about it to fix it, to make sure it doesn't happen again, and that sort of thing. Generally, OEMS may not have to conduct the full investigation that they normally do when it comes to them through other means. And they give you a bit of leeway and slack to fix the problem yourself, as opposed to when they get a complaint and they have to conduct an investigation. And then when they call the agency tells them to flip off, take a hike, and that sort of thing. And it becomes adversarial. So having that good, solid CQI process that picks up these calls before they get to that is critical. And the only way to do that really is have a decent sampling. You and I have talked about sampling in the past, right? Is that statistically it might prove some validity. But from a practical sense, you could miss the most serious of the serious things that could go unnoticed if you're doing a really small sampling of calls versus a higher percentage of calls. The question is, what's the proper, percentage? So, 100% is ideal, but larger agencies in particular can't afford to do 100%.
Right.
If you're doing, a million calls a year, it's going to be awfully hard to audit every one of those calls, right? So you've got to have some other mechanism, but it's not, most people generally, when they do that sampling and that QI process, when they're doing sampling as opposed to 100%, they oftentimes say, well, let's look at our serious stuff like cardiac arrest. What they're missing is those simple calls that they think are simple, right? A BLS call, for example, are the ones that get the least amount of QA activity, because in theory, there wasn't much going on with the patient. They were a BLS patient. But if that patient was having a STEMI and the paramedic turfed it to the EMT, and that's your lawsuit, that's your complaint, then that call probably made it through the Swiss cheese, right? So that's the call that gets tagged,
Right.
is the one that's not. So you really have to make sure you have a good mix of that on the QA side, so that you can determine when it's time to get that legal review involved.
Yeah, you also have to be proactive, because I get that agencies may not have the bandwidth or the resources to review 100% of the calls. But you and I were out there, right? I mean, we had a lot of good days, but sometimes we might have fallen short on our bedside manner. It happens, and it's a occupational hazard. It's going to happen to everybody. But if you can't, if CQI isn't reviewing 100% of the calls, there's got to be some kind of mechanism where you got that, that notion, that gut sense that something might not have gone right. There might have been a family member that might not have been happy with something that you did. And there's got to be a mechanism where you can, and I've seen it. I've seen it on these EPCRs where you can check the box and you can have CQI review that particular call. So,
right.
If you got that sixth sense, that gift of fear, whatever it is, that something might be amiss on the call, check the box, self-report it to your CQI, have them review it. And if you think that, I mean, how do the vast majority of these complaints to OEMS come in? It's not the medication errors. That happens. It's not tube in the belly. Well, I don't even tube anymore. So, but that happens. It's what? It's the
customer service.
It's absolutely. It's the
like
compassion.
Right.
They didn't whether it's they didn't put a hat to warm up the head of the patient. It's always some kind of compassion, argument, some kind of integrity, but compassion complaint to OEMS.
Right.
And then, so what happens? The family member, and by the way, if you get a sense that you got to do this 360-degree analysis when as a paramedic or an EMT. And we think of this in terms of scene safety. We're looking for all these hazards and all of that.
Right.
But I'm going to suggest that if you get a hankering that there is a family member with some kind of medical training, especially a nurse, you want to pucker up a little bit, and you want to pay attention to what you're doing, and you want to make sure you're saying yes ma'am, no ma'am, yes sir, no sir, and that patient is wrapped up, bundled up, that patient is carried out to the ambulance, because if it is not, you're going to get a complaint.
Right.
And you know what happens when you get these complaints? They don't come out and they don't just say, gee, we heard, Paul, that you're probably having a bad day. You called the customer an asshole or something. Like you called the patient an asshole. They don't just do that.
Nope.
They pull the run report. and then there's and it's not just, and then once they get to that, I think it's 1.0 routine care.
Yeah.
Once they start finding hiccups in that one, they migrate to the other protocols that are related to that symptomology, and they start tagging you for that stuff.
Everything's
and then
fair
before
game.
you know it, you got 5 allegations against you. Not just that you were rude or you weren't compassionate to the patient. You got 5 protocol violations, and because you might have done the I don't recall, I don't remember. And these guys are hard-o investigators now. Yeah. We should talk about that too. Yeah. Back in the day when you and I were on the road, it was, I guess, a quieter, gentler, evolving OEMS in Massachusetts, right? Didn't hear a lot about patient providers having their tickets suspended. In fact, I don't think I ever knew that happened.
Right.
Did you ever recall?
It was very rare. Yeah.
Very rare. Yeah. And we knew the investigators. They came from us, and we had relationships with them. We went out to breakfast with them. They really weren't out. They really didn't want to gig you if they didn't have to gig you. That's not the case today.
Nah, there's too much
It is an
accountability.
entirely different
Right.
regulatory environment. They are professional investigators. They get training tantamount to what police detectives. I mean, we get cases where they've actually gone out and gotten security footage.
Right. Well, now there's so much more evidence available, which
Yeah,
wasn't available back then. It's not just word of mouth hearsay. The patient says this, you're saying that. They're now
right.
getting ring doorbell camera
Yeah,
video footage. They're getting CMED recordings. They're getting dispatch recordings. They're getting all the medical records. They're getting the hospital records. They're getting everything. They're interviewing pretty much everybody who was on that scene. There was a case a few years back in one of the states that we work in where they got the camera from the courthouse where the patient was in the courthouse, had a seizure. The providers made him walk out to the
yeah,
stretcher, and they pulled the security camera footage from the courthouse. So, and now we've got body cams we've got to worry about,
yeah,
right? And
yeah,
we've got drones that are recording a house rental. They're doing the house next door is selling. They've got a drone above
yeah,
doing a video of it, and they capture the MVA on that happened in front of the
yeah,
house.
yeah,
So there's so much out there that people have to be very, very careful. And going back to your point, Kevin, of OEMS, once they get started, everything is fair game. There was a case a number of years back, and you and I perhaps have talked about this in the past. It was quite a few years ago now, but the patient called OEMS. The patient called the fire chief of an agency that we work for, and she said, "Listen, my mom wanted to go to ABC hospital. Your providers refused and took her to XYZ hospital, and I want to complain about that." And the chief pulled the record and he said, "No, our point of entry requires that we go to the facility that we went to." And he felt so confident in their care that when the patient kind of kept complaining and wouldn't let go of it, he said, "Listen, we've done the right thing by you." He tried to do the customer service thing, and he said, "If you have a complaint, your option is to go directly to OEMS and complain to them, thinking that they did everything right, and therefore they would get
yeah,
exonerated if they went to the highest level in the land, if you will, of OEMS of EMS oversight." So the patient did called OEMS. OEMS came down and actually cited them for three things instead of just the point of entry. They cited them for
yeah,
not using pain control management on the patient. They cited the providers for walking the patient to the stretcher and then
right.
lying to the OEMS investigator for doing it.
Yep.
So they had a litany of charges that OEMS brought against those providers, even though ultimately the point of entry issue was cleared and they actually did the right thing and were able to prove it. The other charges stuck, which never would
Yeah,
have been presented if the patient didn't go to complain about a point of entry issue. So,
yeah,
once they start, everything is fair game and it opens stuff up. So your CQI process has to look at all that stuff. It has to look for any weakness in the process, in the overall call dynamics. And if there are things in there that could be challenged, you want to challenge those things on a CQI process basis first and fix them, find and fix, and not allow that stuff to happen to the point where if it does get to OEMS or the legal system or even your service medical director, a lot of service medical directors are very tough on their EMS agencies and the providers, and they're very
yeah,
rigid with them in terms of what they allow them to do. And they're not afraid to pull your ticket or to sanction you and limit your ability to work at the ALS level or the BLS level if they find something. So even that can be an adversarial situation on occasion. So you really have to make sure that you're doing this stuff properly.
yeah. And it's the state medical director that is the expert that is advising the government that you are a safety hazard and your license needs to be suspended pending, some rather significant remedial training.
Mm-hmm.
And you got to get a lawyer, you got to get an expert involved right away. You may be screwed. You may have to take a hit on because it happens. I mean, it's complicated out there, and from time to time, we're going to botch something up. So you may have to take a hit on the statewide treatment protocol violation, but you really want to pay attention to these allegations where you were dishonest to government regulators, that you were intentionally deceptive.
Yeah, never
I
do
mean,
that.
that's stuff. I
Yeah.
mean, that's stuff. These guys aren't knuckleheads anymore. You really got to pay attention when they come knocking. They are professional investigators. And like you said, their job is to get bad actors off the road. And if they want more money in their state budget, they got to go out there and demonstrate that they are getting these bad actors off the road. Got to get a lawyer. Don't screw around with this, and you got to tell the truth. But a lot of this is significantly avoidable if you have if you got an eye on the ball and you have a robust CQI program.
So that's the point we're trying to make, right? Is that you want to have a robust program that's proactive and is not afraid to look at these calls critically and send them off for a legal review if you think there could be risk there that could expose you, even if you haven't heard from OEMS yet. And then the other, we tentatively titled this podcast, Have Your Lawyer on Speed Dial. And you really want to have a close relationship with your legal counsel so that you can get those. And then, it's not a bad idea to farm that out to an agency such as ours or, somebody else that will look at it independently and objectively from your own CQI process, right? Let's get another view on this, because as I mentioned, this is a highly subjective process reviewing patient care. People provide patient care differently. Even physicians, medical director physicians, will send a call to medical director A and say, what do you think of this? And they'll say, yeah, everything looks pretty good to me. And then we'll send it to a separate medical director physician and say, what do you think of this? And they'll see all sorts of stuff that they don't like about the call. They should have ALS'd them. They should have done a 12 lead. They should have got a blood sugar. They should have called the sepsis and called the sepsis alert. And they'll go through a litany of things. In their opinion, those things should have been done, versus medical director A who says, no, I don't think they met that criteria. And they have their own clinical logic for why they don't think that. So the problem you have is that you don't know what, and we keep saying OEMS, but it could be a legal defense. It could be another lawyer that you're defending yourself.
Oh, sure.
So it could be other things, right? So whoever's challenging you on that call, including family members and family members who have a clinical background,
right?
They may interpret your run report differently and say, I can't believe you didn't ALS mom when you should have, and she died 2 days later in the hospital because you guys were lackadaisical about stuff and didn't identify the clinical problems with her. That may not have been the case at all, but that's going to be the accusation. So getting, different opinions, even within our own CQI process, we get multiple opinions on a call. We get the auditor opinion, we get the coordinator opinion. When we talk to the paramedic, we get their opinion after we discuss the pros and cons, as opposed to before when they thought they did the right thing. And we get the medical director opinion. So we get 4 opinions on that call. And then from that, we read through and say which of these are valid issues, which of these issues are maybe not so valid. So we never leave it up to one person to say whether everything. And in fact, when you send me legal calls, I review it and have my ops manager review it, and we often pull an auditor and get a third review, and then put all those reviews together before we supply a response back to you. So, and it's because we want to get those differing opinions, pros and cons. What's the worst way to look at this? What's the best way to look at this? And what's the supporting data that we can hang our hat on for defense of this?
Right, it's. Do I, if I'm gonna take on this case and defend this EMT or paramedic, what kind of a case do I have? Because guess who I call as my expert to rebut Bernstein, state medic? I call you.
Right.
I mean, that's it. So,
yeah.
You gotta give your lawyers something to work with. Got to get lawyers and experts involved, early in the process, and imagine the scenario where your EMT or your paramedic gets one of these notices, and there's a litany of protocol violations, and had there been a process in place, or had this been picked up by the run report review process, there would have been ample opportunity to be proactive. Put something in place, if there was some remedial training that on a particular statewide treatment protocol that needed to be done, you can implement that right away.
Right.
If there is any type of customer service issue that needs to be dealt with, and you had a process in place where the EMTs, could have said, "Look, I think you might want to reach out to this person. They didn't seem all that happy with our service." That's a call that if you can, if you can use uh, your compassion, your empathy, and apologize to that patient for falling short. That's not going to OEMS.
All right. We both use that
yeah,
tactic, right? As managers,
yeah,
you and I both
yeah,
had calls from irate family members who
yeah,
I'm suing, that's it. And in some cases, we were able to talk them down off the ledge where they were at the end of it saying, okay, I kind of understand. And they were certainly less hostile and it didn't result in a lawsuit. And that might also involve getting your medical director involved to make that phone call with you or for you, or even as a secondary source, getting I'm the services medical director as a
yeah,
physician. I'm responsible for their clinical care. They did some very good things for your loved one on this
yep,
particular call. There are a couple of areas we would like to improve upon, and thank you for bringing that to our attention, and we'll make sure that that gets done. We're putting together a remediation process for the providers about that very issue. You can do a lot to mitigate that so it doesn't escalate and get out of control.
yeah. So review their own reports. If you can't review everyone, have a process in place, because we know as EMTs and paramedics, when there might have been a hiccup and there might be some problems. We have that sense, that sixth sense. Have a
Right.
process in place where somebody can report that, and have somebody from the agency contact that patient or the patient's family, and start that process, because you want to get a jump on this. If it's something that looks like it's going to evolve and more often than not, it'll go to the state regulatory agency before it goes to a malpractice lawsuit.
Right.
Get a lawyer and get an expert involved right from the get-go. Use your sense. Give us a call. Give Paul and I a call. We'll walk you through it. I mean, that's what we do.
Right.
And have that customer service process in place, where if you think you might have fallen short on the compassion and the empathy, or you got into it with a patient was being an asshole to you. And I'm not suggesting that you sit there and you take it. I mean, you got to have a skill set and some tools in the toolkit to deal with it. But if that happens, report it. And have the agency contact that family and say, look, we were concerned that we might have fallen short in your expectations. We're so sorry. How can we help? Can you tell me about it? Gee, we're so sorry. Mm-hmm. Have a process in place where EMTs and paramedics can self-report, and even if you have your own CQI process in place, consider farming that out for a second opinion. So you believe, and we did the. What do we do? We did the poll, right, Paul? And 7% of the said that they, and I'm paraphrasing, that they had a world-renowned Nobel Peace Prize winning CQI program.
Right.
Yeah, all right.
Everything was good.
Yeah, I'm embellishing.
Right.
I'm embellishing. Yeah.
Right.
So everything was great. But you may, and that may be, you may have that state of the art CQI process. But if a case like this comes in and you think it's going to generate some negativity, some untoward governmental agency action, get a second opinion. Send that to us. We'll review it. We'll do our 360 analysis on this and score it, and we'll talk about the strengths, the weaknesses, the opportunities, and the threats to the organization, based on this particular call.
So we didn't mean to turn this into a sales pitch, but it kind of turned into that. But if we can help, if you think that you'd like to get us involved in some way, you can do that through our website, www.gerardasoch.com. And on our website, you can send a request to us, or on our business partners page, Kevin, Criminal Defense Northampton. If you're looking for the legal services part of this, you can connect to Kevin through our website, through the business partners page on our website. So, closing words for folks that we haven't already beat the dead horse on?
Well, I mean, it's be proactive. Whether you're an EMS provider, an EMS agency, I'm going to suggest put a lawyer on speed dial. Mm-hmm. You're one complaint away from unbridled anxiety, stress, career-long embarrassment. If you're a provider and you have this on your record, that you were intentionally deceptive during it's one thing if you have a hiccup. I had a hiccup. It happens all the time. We're flawed. We're not infallible. But the deception, the lying, that's something that you're going to want to argue away. And if you have to take one on the medical aspect of it, you might want to argue the deception away. Lawsuits. And as EMS providers, we have an obligation to leave the agency and the profession better than we arrived. Help your agency shore up its EMS, CQI, and customer service programs. Start a committee to improve EMS, CQI, and customer service. Start doing more surveying. Step up. Have your CQI program audit all of your run reports. That's what, if I went back on the road, that's what I would be checking that box off on everyone. And, I guess, we'd love to help EMS agencies shore up their EMS CQI program. Give us a call. Check us out online. The return on the investment calculator. That's pretty much what I have, Paul.
Well, thank you all for listening. Thank you, Kevin, for your input. And you know where to find us if you need us. And even if you just want to talk some of this through and get some ideas, we'd be happy to chat with you. No charge.
Yeah, absolutely.
Just for the sake of chatting. So GerardAssociates.com. Thank you for listening. We look forward to talking to you again soon on our next episode of the GNA Way. Have a good day.
Stay safe, everybody.
On 5.